Ladies and gentlemen, dear colleagues, dear friends, as you can imagine, when I was invited to present some final remarks to this August company, I was nervous. And when I'm nervous, I'm either listening to opera or reading about opera. And that was a very good preparation for my brief remarks, because I read about Ernest Newman, a famous English music critic, and he apparently had been to the opera, and he was interviewed about the opera, and then the question was put to him, a rather strange question perhaps, but what did he think about the interval of the opera? And then he said, well, and I don't know whether he liked intervals or not, or opera or not, probably he did, and he said, well, I'm often thinking about the question, what would be better? An opera without an interval, or an interval without an opera? So then I knew what I would start with for this meeting. What would be better? A conference without closing remarks, or closing remarks without a conference? Now I know the answer. Provided the conference is good, I would like to have the conference. And provided the concluding remarks are brief, I wouldn't mind the closing remarks. So that's how I'm going to operate. The conference was good. We all know, and we have witnessed every imaginable aspect of the principles of UNIDROIT has been dealt with and has been discussed. And that was good. So now it's my task to present you with very good closing remarks, which is very brief closing remarks. And I could not prepare the closing remarks before the conference, so I sat here and just made some notes with all speeches. I just made some notes, and then I decided to tell you what struck me, not in all interventions, but in a number of interventions. Things that were at least to me new, or if not new, interesting and striking to me. I'm not going to say many personal things, but the very first thing I'm going to say is something personal, because Pilar Vizcacilla said something relationship between principles and conventional international relationship. At that moment, to 1970, when Joachim Boon had been attending on the, and we heard that he heard that I was go to the Netherlands, be friends, and there Joachim in the then press Monaco, highly impressed by the, and so between CISC and principles working all level. Next thing that struck now, the importance of the system. If you have a system of law, it tends to fill gaps, and it's much more easy to fill in a system that's not perfect. Illuminating as any things able to be context, evident systematic way, but much as possible to which have, so that by them you in a sense work at the same time at an unwritten system of the law. second thing that struck me was Pietro Galizzi, who said, Article 1.7, fairness, good faith, is the big word in this time of ESG. And in the sense, of course, it is easy to understand because ESG is all about, well, justice, equity, and then, of course, a word which refers to that concept of the law is and cannot be other than a key word. But nevertheless, talking about it in this way opened up to me, at any rate, again, the importance of good faith. I will have to say something more about good faith later, but that was the first very illuminating reference to the importance of good faith in this modern period of entirely new law, because ESG will bring us entirely new law. And we must remember that that is also a matter of fairness and good faith, whether we call it like that or whether we don't call it like that. I was impressed also and struck by the words spoken by Chris Seppala, in particular his remark that the FIDIC rules are so dense and so extensive and so numerous that it would be very important to have a substrate such as the UNIDROIT principles underneath, because at first glance you would think UNIDROIT principles cannot have much to do with such a highly developed technical industry as the construction industry, but it was revealing to me that this might be a very good combination. And what is also important, and that is something UNIDROIT practices already so many years, is working together. UNIDROIT works together with international organizations. For instance, in our latest work on agrarian contracts, we work together with FAO and other international organizations, but we also work together with private interest organizations, and FIDIC is something, well, I wouldn't say in between, but something different again. And it is, I think it would be a very good idea to work together with such a important and interesting organization. And you showed us that there are a number of UNIDROIT rules that do not have a pendant in FIDIC and the other way around. So perhaps it would be highly interesting to do some work together. For instance, you said we have important rules about giving indications or instructions in a long-term situation. Who should do what? Well, that may also be relevant in other long-term contracts. Eckert Breuderman said something which I found very interesting. You often have to deal with employers or other contractual parties, states, that give you a contract which you cannot change because they are much more powerful, and the private party has to accept or will miss the contract. And then he said, well, that's fine, no problem, but just try to get in one small extra phrase or article. Everything all right? Well, that's not in that phrase, but please let us agree that the contract will be, if necessary, if interpretation is necessary, it will be interpreted in good faith. That's all. That's all you need in case of problems. And I found it a very wise remark, and I wonder if that will always be possible. But if it will be possible to insert that little innocent clause into that contract, that would be a very good idea. Christina Ramberg said that it is very useful for counsel in an arbitration case to refer to the UNIDROIT principle, because that is, for a number of reasons, very useful. First, If the other party doesn't know them, you have won a point. If the arbitrators don't know them, they will know them in the future. And if the arbitrators have to apply their own law or whatever other law, and they are hesitant about whether that would be a good solution to this international case, and they read the principles and they see that it is concurring with what the principles say, then they are, well, satisfied and will have learned a lesson and will be very sympathetic towards the principle. And then came Dominic Spencer Underhill, and we had this long discussion about good faith. That is a hopeless question. I entirely agree with who said it. I think Stefan again, and also Henry. It is a dangerous subject because it will create an enormous cliff, not only between civil law countries and common law countries, but also between civil law countries who, well, have good faith, but because they all have it in a different manner. I dare say, I've been, well, part of my life I've spent on a commentary in four volumes on the law of obligations in the Netherlands and some comparative law around it. And there is a large chapter on good faith, at least 40 or 50 pages. And so I was when I was young and started this commentary, I went to look into other civil law jurisdictions, and where they also knew good faith, and they were all different. Even between Germany and the Netherlands, if I may become local for a moment, Germany and Netherlands, neighbors, I always thought that Germany was really the cradle and the example country for the application of good faith. Gute Glauben, nicht gute Glauben, treu und Glauben, but that is an easy distinction. I don't know why Mr. Underhill said that he couldn't understand that, if he said it and not somebody else, because that's a quite easy distinction. Gute Glaube and treu und Glauben. You can explain it in 2 words. But the problem is, where do you apply good faith? In which situations? We had one point later on in the discussion. I think it was, well, I made a little note, but somebody said, in that case, the Dutch or the Danish court just implied, the English would say implied, an obligation into the contract. That is to say, we would say, created a new obligation in the contract on the basis of the supplementary function of good faith. We would call that supplementary function as opposed to derogatory, restrictive function of good faith. Now, those are very, very difficult questions. I have seen that, for instance, in Germany, where I thought that the restrictive function of good faith was very important. I spoke to German professors and they say, no, we don't have that function of good faith. And that was, I think, Professor Drobnisch or Professor Zimmermann, one of the really big guys in the German legal world. By the way, if you want to ever to work on good faith again, which I would not counsel, not advise you, there is already a book on good faith in European contract law. It is by Zimmermann and Whittaker. It was the first book of the Trento project, appeared 2002, very interesting book. It is not, let's say, it is not structured as the common law, the UNIDROIT principles in black letter rules and comments and examples, because that's really unique and really clear for every reader. It is a more learned book, but it has also cases and it has also very much explanation. So you could at least perhaps also start by reading that book, or should I say that book again. Let me see whether I have some other remarks. Jose Antonio Moreno Rodriguez said, the investment treaties are useless for private lawyers because they are formulated much too broadly, in a very broad way. And that is why I personally find it very interesting and a very good decision of UNIDROIT now to work on incorporating those concepts into contractual language and making more concrete those, in essence, public law notions for use in the private law context. Let me see. Isa Frederick said, in my country, the courts shape the law and they do it with the help of good faith. And that is interesting. Perhaps that's the only, let me say, country creating law by case law and using good faith, because we always associate this incremental way of lawmaking by courts with common law, and they don't use the good faith in this way. There are examples, we have heard some of them, of exceptions, but normally the English courts will not use the good faith in that sense. And in South Africa, which is of course a mixed jurisdiction of common law and civil law, but only civil law of 2000 years ago. But at any rate, they work incrementally in case law with good faith. And of course, we should have known it. I should have known it. And I have known it once when I was much younger, but I had forgotten. And this was a very interesting remark reminding us of that possibility also in existence. And now I think I'm nearing the end of my Maria Ignacia Vial Unduraga reminded that Jünger, Professor Jünger, whom I have once heard in a conference with the following phrase. I've never forgotten it. He said in a purely legal context, it ain't worth a thing if it hasn't a swing. If it ain't got a swing, it's just no thing. And but what he said also was that it is possible to choose UNIDROIT principles, applicable law in the PIL sense, so applicable law as in an international commercial contract. And that reminded me, and that is the second and last personal remark I want to make, that in 2002, UNIDROIT celebrated its 75th anniversary with a beautiful, large conference somewhere in one of the papal universities, I think Gregorian. It was on close to the Vatican, and I was very honored that I was allowed to speak there about the system of UNIDROIT and unification of the law. And there I have defended that same point. And Joachim, in his well-known book of many editions, An International Restatement of Contract Law, which of course I reread for this occasion, mentioned this in one of his, I think, 850 footnotes. So this will go in eternity. This is in eternity. Once I wrote a poem, because I like to write sonnets about legal subjects. Yes, I've done strange things in my life, and the last two lines are, I cannot rhyme in English, but in Dutch it says, "When I am dead and forgotten, I will always live forth in footnotes." And Joachim will help to realize this ideal. The future, I know nothing about the future. I'm not going to say anything about the future. I know about the present situation, that the UNIDROIT principles are very important as a general basis for contract law, and general rules are always the most important rules. Detailed rules are, well, I wouldn't say a nuisance, but they are not interesting, not intellectually stimulating. It is the general rule that is important and beautiful, and that is what UNIDROIT gives, and what many legislators are not able, perhaps not willing, but also not able to give. And UNIDROIT has given the world their general system. It is everywhere in all contracts. It is useful. And as far as the future is concerned, that's of course a matter of the Governing Council. And I would, at any rate, but that is useless because the Secretariat and the Council know, at any rate, continue the practice of working together with other international organizations or organizations of professional lawyers. Work together, you get new ideas by working together, and you will have more success with your instruments when working together. And you knew that, of course, but I nevertheless wanted to say it because I think it is such a very good habitude, all those languages. It's even worse than law, all those laws. It is a very good habit, and something more. It is an inclination, a way of living, working together, seeking inspiration from others, working together with others. And that is what I would say as my last words in 40 years. In fact, if I may be more, a little bit more precise than that, because 40 years would put me on the same level as another colleague in UNIDROIT. 40 years is good, but it can better, because 41 is better than 40. And the 41st year was my first year, and that was when my honored predecessor, Georges Sauveplan, who was also, I think, Deputy Secretary General, but you may better know your own institution than I do. But at any rate, he was for a number of years working in UNIDROIT. Then he became member of the Governing Council. And then he fell ill. I think he fell ill, but I'm not certain, because he always also loved life, and perhaps he had planned a beautiful travel to who knows where. He liked to travel. He was remarried, and he wanted to enjoy life. And so he said, "I'm ill. Would you please be my replacement for the Governing Council in '83?" And that was my first, and so 41st Governing Council meeting. I have enjoyed that. I've enjoyed them all, especially when the president was busy, because when the president was busy, and Professor Limonati was always busy because he was chairman of everything which didn't function well in Italy. So often he was not present at the meetings. And then, since I was doyen, and that's for the last 20 years, I was allowed to chair the meeting. And Professor Mazzone, in his introduction to the book that has appeared in 2016, has written that it was such a pleasure always to chair the Governing Council, because in spite of the different type of personalities in that council, academics, diplomats, government officials, it was always a meeting of good temper, never political. Of course, there were wishes that may have gone back also on discussions with your own homeland, home country officials, but it was always a very courteous, very pleasant meeting. So I have been really always been very happy in the governing council, and now I think that is my last word. Is that a suitable last word? Yes, I think it is a suitable last word. Thank you very much. That would do that.
I don't think we need to say anything else. Just thanks a lot for these 2 days. We will repeat them at some point, even with no reason for anniversary. Thanks a lot. It was extremely enriching for us. And see you very soon. Keep on with us every single day, please. Thank you.